everyone. Welcome to HOA Fight Club. I'm Raylene Chapano. Today I'm going to discuss the differences between contract law versus covenant law. I know that we've talked about this before with a lot of my videos, but I think that as we're coming in to write legislation, the legislators have to understand what the homeowners and consumers don't understand prior to their purchase. Most of us think, the HOA is this association that's supposed to take care of the homeowners, take care of the common areas, take care of the properties. But what they don't realize is that they are agreeing to a lot of different covenants that make it almost impossible for some people to live. And they don't realize that these covenants are mandatory and that it's not the fact that the covenants are mandatory, it's the fact that the people that are enforcing those covenants have all power, have ultimate power. They have the right to take your home. So let's look at some of the differences. HOA and condo associations can be confusing for consumers when they're purchasing a home. Most consumers assume when they purchase their home, the association is obligated to follow the governing documents, just as the members are required to follow the same covenants. Consumers believe that when they purchase into these corporations, there is governance by the attorney generals of each state. So they don't realize that there is nobody that is monitoring those that are monitoring the people. So we have the board is monitoring the homeowners, but who's monitoring the boards of these associations? These are corporations under the law, and they shouldn't have the ultimate power to take our homes with no due process offered. The Constitution states if you even get a fine for over $25, you're supposed to have due process. So this is a lot more. This is actually taking people's home under the guise of it's what's best for the association. And what I'm going to show you is that this really isn't what's best for the association. Both the association and the homeowner get harmed almost, well, not equally. Sometimes the association gets harmed more than the homeowner. So let's look at a few things. Contract law requires two or more parties to negotiate and agree on the duties of each party. And if one party does not fulfill their obligation, the other party can sue for damages under contract law. Well, in HOA condo associations, you cannot sue for breach of contract. So if an attorney that you hire mentions that they're going to sue for this breach of contract, in most states, breach of contract is not applied to these corporations. There is no contract between you and the board or how they're going to act. Your contract is with the association, and there is no contract. It's just this is the law. So you don't, whatever the association believes that should be enforced, which the association is the board members at the time. So those board members can cause a lot of damages if they're not following the covenants also. So let's look at covenant law. Covenant law has been established into governing documents, which can be amended and restated at any time. They do need the vote of the people, but a lot of times people or boards are restating them without the needed vote that they should have before restating them. And then they just say they got that vote when they put that contract in for the county when they amend it. So I have a lot of issues. There's no verifications of the votes on a lot of these, and we really need some accountability there. The contract law has established governing documents which can be amended and restated. The documents create the guidelines for boards to enforce fairly and reasonably. If the board fails to do their duty and cause damages, the members cannot sue under contract law for damages. So that really kind of, it's not really a contract, and that's why they're saying you can't sue for contract law. The association has no obligation in the laws for them to follow the law. So, they've made it really convenient for the board to violate the law, but the homeowner can't. So, and in doing so, all that did was help the property managers and attorneys who need conflict before they can be used in these associations. So they really want that conflict. They need that conflict for them to have a job. So, if the board fails to follow these covenants, they're held harmless. Members can only sue in civil court and must establish damages. So you can't just sue the board because you feel that they did things wrong. So if the board is ignoring the budget or not doing what's best, or they're charging special assessments and the money is not accounted for, they're not giving you records, those are things that you could sue for, but what damages did they cause you? So they're going to ask you that. And if you have no physical damages, they're going to laugh you right out of court. court, no attorney will even take your case. The attorneys know that there is no profit in representing the homeowner. They know the only profit there is actually to represent the association, because that is where they get paid no matter what. So let's continue on this so that I'm not just harping on that. So boards can use the funds of the association to defend their actions and have unlimited use of the monies of the association to deny, delay, and deflect all damages. High cost attorneys take advantage of the unfair balance of laws, thus abusing the member and association as a whole for their own personal gain. Those attorneys don't represent these associations to protect the association. They represent the board to hurt the associations in the long run. And I'll keep explaining that. High cost attorneys take advantage of unfair, unbalanced laws and abusing the member of the association as a whole for their own personal gain. All attorney fees are added to the account of the homeowner that is being fined or is past due on their assessments. That member, if they can't afford their assessments, how are they going to afford these attorney fees of $500 an hour? But all those fees are going on to that person. So if that person at the end of the day, the board does foreclose on them, those attorney fees are still due. And I've seen right now, I have a client that had over $54,000 in attorney fees that she had to pay off to get her home to be safe so that they wouldn't foreclose on it. So what she was past due on was the attorney fees, not the fines and the fees that they want to add to her account or special assessments. There's no governance over what these people are charging you. There's no governance that they can't charge you differently. There's just no governance. So if the government didn't have any governance, the municipality doesn't have any governance, then we, the people, could take them to court or to the attorney general and say, hey, these people aren't doing what they're supposed to be doing. They're lying and cheating and stealing. But there isn't that. There is no governance over the associations for these corporations. So these corporations can steal people's homes. You find that the attorneys are doing all of this for their own personal gain. How does this help the association? So I think that that's something that we have to look at. Homeowners who violate the covenants are fined and forced into foreclosure. The member pays all the fees for both sides of the disagreement. If they can't pay in 30 days, liens are applied and foreclosure commences. No one cares about the damages the attorney fees cause the members. All amenities are taken away and the bullying tactics are used to cause a member further damages. There is no way a member can afford to pay all those fees. You're just forcing them. There's no salvation for them. They have nothing left after you charge all these late fees and attorney fees and interest rates, and then they're left homeless. Their credit is ruined. They have a mortgage that they'll never be able to pay, so they go bankrupt on that. They go bankrupt on everything, and then their credit's ruined and they have no way to rent a home. So now they're homeless. What does our government do to protect those homeowners? What is the law that protects them? Not only do the covenants hurt the members, they hurt the association. These covenants are written to protect the developer's interest in the corporation when he's first putting it all together. He wants to make sure that he has godlike powers over his community, and he should, why he's in charge of it. But after he's in charge of it, there should be a set of declaration and bylaws that is very standard that everybody should use, and those covenant should have to be a contract that is signed when you purchase that home. Both the board that's serving at the time and both the homeowner or the consumer that's buying into that corporation should both have to sign the documents they are enforcing and agreeing to be enforced on, which there's no signatures. We don't have any signatures that are required by law to be given. There's no attorneys that are helping homeowners or warning them. There's no attorney general warning that says, hey, we need to help these homeowners. We need to make sure they're educated before they purchase a home in these corporations. We should let them know that they're not going to have any governance, that the boards can do whatever they want, and we won't even help them. That should be the warning. You are giving us warnings about smoking a cigarette, that we could die in 20 years by cancer, but we could lose our home in 90 days, and the Attorney General's office is silent on the issue. We can't even get them to issue an opinion. So legislators they're considered let's start over. Legislators consider the Uniform Acts constitutional. I say the creation of these acts by the legislators is the unconstitutional act. The legislators creating the laws and creating uniform acts are the ones that have violated our constitutional rights. It's not the Uniform Act. It's the fact that you created an act that violates our constitutional rights, that allows for us to lose our right to due process when being fined, when protecting our homes. There's no Homestead Act for us. There's all these things that you've taken away from these homeowners without them even knowing. And they have no idea that they can lose their homes, that they're signing over power of attorney to these homes. And there's already there's a lien already applied on those homes if the board wishes. And those boards don't have any training. They're uneducated. There's no governance to make sure that they're doing what they're supposed to be doing. There's property managers and attorneys that are taking advantage of the laws for personal gain, and that is predatory. We are establishing that these actions by these attorneys, by these trades groups, can be predatory. I'm not saying that they're all predatory, but they are predatory actions. They are lobbying for non-judicial liens and super priority liens and non-judicial foreclosures and taking your home in 90 days. They don't want to see that stop because that's going to save the association. Well, you know what? That hurts the association, because when that homeowner can't pay, that association still has to pay for the bill. They still have to pay all those attorney fees. They don't get to just write those attorney fees off when they go after a homeowner and a homeowner goes bankrupt. Those fees are still applied. And guess what? Those attorneys still get paid. And the homeowners that suffer are the ones that are still living there and their funds are being used without them even knowing that it's being used on attorneys, because they have no right to the records of the association, because our legislators have given it away. No law shall be passed granting to any citizen, class of citizen, or corporation other than the municipal privileges or immunities, which upon the same terms shall not equally belong to all citizens or corporations. How are we allowing these corporations to foreclose on us with no due process? I get it. You want the association, you want the members to pay, and you want to have some sort of a condition for them to pay, but you forgot to put the governance in over those that are governing the homeowners. Those are the people that are hurting us. Those are the people that are hurting the homeowners and using their homes for their own personal gain. Attorneys are making millions, probably billions. They govern how many thousands of communities that they're doing this in, and we're just allowing it. You know, I always go back to the civil rights, under 42 USC 1983 demands that the government protect the United States from anyone who breaks due process and our civil rights. This is exactly what they're doing. Due process: a plaintiff must show that he possessed a constitutionally protected property. Our property should be constitutionally protected, and that we were deprived the interest without due process of law. If you're taking our homes and offering us no due process for the fines and the fees that these boards that have no power of the municipality are doing to these homeowners, that's a civil rights liability violation. I don't know what to tell you. I think that our legislators that are looking at it like they did nothing wrong, you're the ones that are doing things that are not constitutional. You're allowing for these laws that were not lobbied for the homeowner. They were only lobbied for to protect the attorneys, the boards, and the property managers, and any other professional agent that takes advantage of a homeowner. They're all held harmless, and we have to pay. We lose our homes in 90 days. Who's protecting the homeowners? Who's protecting their rights? Who's demanding their justice? And why are we allowing these corporations to be above the Constitution that is supposed to be the most sacred? If we are allowing them to be above the Constitution and ignore due process, we are giving them the special privileges of a corporation. And corporations cannot be given special privileges. They have to be formed under general laws and shall not be created by special acts. All laws relating to corporations can be altered or amended or repealed by the legislator at any time. And all corporations doing business in the state may, as to such business, be regulated by the legislators. They have the law. They can be limited and restrained by law. Again, I ask, who's protecting our homeowners? Who's protecting their interest right? Who is protecting their property rights? Who is governing those people that are monitoring our biggest investments of our lifetime? We've given them all the free pass to take advantage of the laws, to be predatory, to hunt us down, to foreclose on us, to apply super priority liens over our mortgages, and to steal our homes in 90 days. Those are the laws that are passed. Those are the laws that everybody in Washington state and the legislator thinks is fair. I really disagree with this. I think that you guys are looking at the wrong middle housing crisis. I think that if we don't prepare for this, this is going to be the biggest crisis Washington state or any other state will suffer at in their lives. I mean, this is it. This is when these people cannot afford to pay their mortgages, they're sure going to cut their HOA payment first. And guess what? That'll be their biggest mistake, because that HOA will steal their homes in 90 days for less than $200. Oh, they have to be $200 past due. If we think that that's fair, that they should be able to take your homes above your mortgage and leave you homeless for that $200 mark, I think you should call your legislators, because they all agree with that. They all think that you should lose your homes in 90 days, and that the homeowner should have no right to due process. And that's what we're disallowing. And what we allow will continue. All right. These are my opinions, and I'll see you on the next one.